Hi, it's Keith Bates here, and today in my direct mail inbox there was a question, and the question was, is it legal for me to change the logo of a product and then manufacture that product? And that touches on all sorts of intellectual property issues, so it's worth unpacking. Firstly, there's the question of what does it mean, is it legal or is it illegal? It's not criminal to infringe intellectual property, but you can get sued and end up having to pay damages. And also your infringing activities, or you may be ordered to stop your infringing activities. Now, if you then don't pay the fine and you continue to infringe, then you're in contempt of court, and then it does become a criminal matter and you can go to jail. So that's the legal side of things. So let's use an example to kind of unpack the question. Imagine there's a furniture company, say, called IKEA, and they have a particular cupboard that they sell. So you can't use the IKEA logo because that's trademarked, and if you use it you're infringing and you'll get taken to court and blah blah blah. So you could make a similar cupboard and change the branding and come up with a different name, and then you'd be clear on the trademark side. Now, the next thing that IKEA will have is a design patent, as it's called in the US. I can't remember what they're called in Europe off the top of my head. That protects the form of something, you know, the way it looks. So they will have a design patent on their cupboard, most probably, and that means that if you make an identical looking cupboard, then you'll be sued for infringing that design patent, and the same thing happens again. So you'll have to change the design of the cupboard somewhat, and it's not just enough to change the color, it'll have to look substantially different. So that's design patents. Now, IKEA will then have some utility patents, probably, on the way that the cupboard is assembled. So, for example, how the joins work. You know, those funny little screws where you put in little plastic things and twist them around, it tightens the thing together. Because utility patents protect a method or a system or an invention, a way of doing something, basically. So if your cupboard is assembled in the same way as IKEA's and they have some utility patents protecting the way it's assembled, then you'll be infringing those utility patents. And there you have yet again the chance of being sued and paying fines and having to take your product off the market. And then finally, the product will come with an instruction manual that explains how you assemble the cupboard, because IKEA makes self-assembly furniture, and that manual is protected by copyright. And copyright's an interesting one because all the other ones you have to apply for and pay a registration fee, and in the case of patents, pay an examiner to look at it and argue with it and prosecute it in order to get the patent. But copyright, in most cases, is automatic. There's this thing called the Berne Convention. I'm not 100% sure if the US has signed up to it, but basically when you write something down in fixed form, you as the author automatically, in most cases, get the copyright to that document, or your employer if you were employed to write that document. So they'll have the copyright to their instruction manual, and if you copy the manual, include it with your product, now you're also guilty of copyright infringement, and you can be sued for that too. So that's the way that companies protect their intellectual property and their designs. Of course, the final question is one of a moral issue, which is if someone's gone and invented something and made it, it may and hasn't protected the intellectual property, then you're free to go off and copy it without fear of being sued. But of course, that is morally wrong, so that's really up to your own conscience. Anyway, I hope that answered the question. Hope you found it interesting. See you in the next video soon. Bye for now.